an appeal in the matter of S. a child.
Yes, good morning, Miss Brown.
Good morning, my lords. I appear for the local authority today together with Miss Pollack. Miss Pollack represented the local authority at the hearing before His Honour Judge Wicks.
Yes.
With us today is the team manager, Miss Wesley, who sits behind Miss Pollack. Miss McGlynn of King's Council, together with Miss Jones, appear for the mother. Miss Jones represented the mother at the hearing before His Honour Judge Wicks. The mother is present in court at the back, sitting on your left of the two at the back. Right. And her solicitor, Miss Lindo, is also present in court. The father is not present. He is represented today by Miss Reid of King's Council.
Yes, well, we had an exchange with the office about that, so here's Miss Reid.
Together with Miss McIntosh, who represented the father at the hearing before His Honour Judge Wicks. Your lordships have a short skeleton argument which has been added to the court bundle, which supports the mother's position.
Yes.
Mr. Howe of King's Council, together with Mr. Froud, appear for the child. The children's guardian, Miss Geraghty, is present in court, and also the child's solicitor, Mr. Wartall, who represented the children's guardian at the hearing before His Honour Judge Wicks.
Thank you.
And Miss Gridley, a paralegal, is also present in court.
Right, thank you very much. Well, we have read, I think, all the key documents. Thank you very much for the bundles, very well all put together. Have you had a chance to talk about how you're going to divide the day up?
We haven't directly. We assumed we would go in the usual order, my lord.
Well, the usual order. I haven't discussed this with my colleagues, but for my part, I wonder whether we might hear Mr. Howe before Miss Macklin and Miss Reid. Would that make sense, as this is an appeal? I think that would. Do you agree with that, Stephen?
Yeah. And
is that right, Mr. Howe? Do you mind?
Whatever's just the court, man.
Yes. Well, I think we should be able to finish this within the day.
We're all confident of that, my lord.
Yes. Well, I can tell you, we will be. So that the mother knows in particular, we're going to reserve judgment, so we won't be giving any decision today. I know that's a disappointment, but the practice in this court is, in every case, we reserve judgment so we can think about the legal arguments that you put forward.
Thank you, my lord. Of course, we are being live streamed, and therefore we will simply say the local authority, mother, father and child.
Absolutely.
Any identification of the family.
That's why we do that. It sounds a bit impersonal to call her the mother and the father and the child, but that's because we want to keep it anonymous. Thank you.
Thank you. As we set out within our skeleton, the issues in this appeal are not novel. We say very simply that the judge's reasoning does not sustain the order that he made. And in developing the arguments that we make in our skeleton, I propose to first address the proposition that there should have been a request to the judge for further or expanded reasons. Second, address the judge's evaluation of the harm and the likelihood of harm to the child, because we say that risk is central to the appeal and underpins all of the grounds.
Evaluation of risk.
The evaluation of risk. Yes, my lord. And then third, address how that evaluation of the evaluation of the overall welfare advantages and disadvantages of the realistic options was compromised by what we say is the failure to properly evaluate the harm and risk of harm. Dealing first with expanded reasons, we say, as this judgment is deficient in evaluation and analysis, it could not be remedied by a request for clarification of reasons or by a request for further and expanded reasons. At the conclusion of the hearing, Ms. Pollack made an oral application for permission to appeal, and on the basis that the potential risks to the child with the mother had not been properly evaluated against the extensive background history and mirror concerns, essentially the heart of the appeal before this court today. And I pause to cite my Lord, Lord Justice Baker, from paragraph 9 of YM, Care Proceedings, Clarification of Reasons, 2024 EWCA Civ 71. It's not in the authorities bundle.
Well, that's unfortunate.
It is unfortunate, and I apologise for that, but of course that the bundles were put together.
Well, what's the proposition that you're...
The proposition I'm putting is it's paragraph 9, and within that paragraph, my Lord said the judgment is not a draft paper for discussion. It's the definitive recording of the judge's reasons, decisions, and the reasons for reaching them. And my Lord went on to say it's therefore inappropriate to use a request for clarifications to reiterate submissions or re-argue the case, or to cite part of the evidence not mentioned in the judgment and then ask the judge to reconsider the findings. And what we say is that in this case, a request for further or expanded reasons would have required Ms. Pollack to list, in a very long way, a long list of the parts of the evidence that were not mentioned in the judgment, and ask the judge to reach a different conclusion. And that's clearly not an appropriate use of a clarification request. The correct forum for the consideration of the adequacy of the judge's evaluation, analysis and decision is this court, and that is why the appeal was brought. I pause to say that, of course, had the judge analysed the potential risks to the child against the background history and mirror concerns, but been light on his exposition of that within his extempore judgment, in responding to the oral application for permission to appeal, he could have provided further and expanded reasons. But he didn't. He refused the application, and he confirmed that he had undertaken what he described as a balancing exercise in accordance with the relevant law. And essentially that underlines that he considered that he had provided sufficient reasons for the decision he reached. He confirmed that the judgment that is under appeal today and the subject of the appeal is the definitive recording of his decision and the reasons for reaching that decision. For leaving the issue of clarifications, it may be said that, of course, the judge should have been asked to correct what we say was his error in setting out the position of the children's guardian, and that request could have been made either by the local authority or indeed on behalf of the children's guardian. But even had that request been made and the judge had confirmed that or accepted that he had misunderstood the guardian's position and that the guardian was in fact supporting the local authority in inviting the court to make a care order with a plan for adoption, we say that that would not make a difference to the appeal and the judgment. It would not, even had that been corrected by the judge at that stage, have remedied the central issue at the heart of the appeal: the absence of the proper evaluation of the future risk of harm. And I shall move on to that now. We can see, and if I take your lordships to the judgment at A106 in the core bundle, so A107, the judgment begins at A103, and at A107, paragraph 24, the judge read into the judgment the legal principles that he needed to apply. And that is set out fully over the course of A107 and 106, A107 and 108. And of course in Re D, it sets out absolutely clearly halfway through the paragraph that is cited, and the judge is citing the principles enunciated by Lord Justice Peter Jackson. Yeah. And it's the passage that begins, "The court must therefore evaluate the family placement and assess the nature and likelihood of the harm that the child would be likely to suffer in it, the consequences of the harm arising, and the possibilities for reducing the risk of harm or for mitigating its effects." And likewise, slightly differently, but it's essentially the same test set out beginning at the bottom of the page, the passage citing Re F. "The questions that the court should ask itself when assessing risk of future harm and setting it in context. What is the type of harm that might arise? What is the likelihood of it arising? What consequences would there be for the child if it arose? And what steps could be taken to reduce the likelihood of harm arising or to mitigate the effects on the child if it did?" So the judge took that step, set that out, and then goes on at paragraph 25 to read into the judgment the threshold, which again is all relevant to the assessment he should then have gone on to make, because the threshold sets out the harm and the risk of harm to the child. And within paragraph 1, and this is at A108, the threshold included the fact that there being no evidence, and there needs to be a correction to the English, but there being no evidence that this behaviour would not continue in the future. And that was part of the threshold he read into the judgment. In paragraph 2, within that paragraph, the threshold included the harm that would result as a result of the parents' inability to remain apart from each other. At paragraph 3, going on to 109, the events in December and the admissions by the mother about her engagement with the father, her allowing him into the home and allowing him to have time with the child. Yes. And then at 4, the likelihood of significant harm despite the mother understanding and again having insight into the harm the child could be caused through witnessing domestic abuse.
Yes. Now we must remember, mustn't we, that the threshold document sets out how the threshold was said to be crossed at the date protective measures started being technical.
My lord, yes.
Which would have been some time when the proceedings were started. Is that what you would have said?
Yes, and that is
July 2023.
Just after the child was born in July.
After the birth of the
so
child.
that is over 18 months. It's 21 months before the final hearing in March 2025.
My lord, yes.
The end of the final hearing, yes.
But it represents, of course, as my lord says, at that date, but that has to form part of the assessment of the risk, and it sets out the factors that have to be weighed into that evaluation, and this is set out both in the skeleton, our skeleton, and indeed the skeleton on behalf of the child. It's paragraph 31 at A29. and it's the judgment of President Sir Andrew McFarlane in Re B, the Child Adequacy of Reasons from 2022 EWCA Civ 407.
Yes.
That the task of evaluating threshold goes to the core of the judicial exercise in every case. It is, in essence, what the case is about. And when it goes on in that sentence, unless the court has a clear and detailed understanding of the basis upon which it finds, if it does, that a particular child is suffering or is likely to suffer significant harm, substantial difficulties will be encountered when the court then moves on, as it must. It's an imperative, as it must, to evaluate future risk of harm at the welfare stage. And it's that aspect that we say is lacking in this judgment. And then we see what the judge did to follow on from having read in the passages from the cases and then the threshold. We see his assessment of risk. It's paragraph 30. And he says the risks in the case relate to domestic abuse, identifying the resumption of the relationship with the father or entering into another abusive relationship. But then we get the single line about the assessment of harm to the child. The potential harm to the child, emotionally and physically, should either of these risks materialise, is obvious. And then he just simply moves on to what can be put in place to mitigate those risks. And it is my submission that the catch-all that the judge puts in at paragraph 27, where he tells this court that he did not propose to summarise the evidence he had read and heard, but to keep it in his head, kept it all in mind. It doesn't help to work out which parts of the evidence that were in his head about the harm to this child, the likelihood of harm, the future risk of harm, and what he derived from the key features of the evidence.
Yes. Well, can I just make sure I understand exactly what happened here? Because the final hearing took place over several months. In October, he heard evidence from the mother, the social worker, mother, guardian. We have transcript. And the focus of that, much of the focus of that evidence was on this precise question. He doesn't refer to that evidence at all. Then we have the statement of agreed facts, which was prepared at his direction at the case management hearing on, I think, the 6th of March.
My lord, yes.
Can you help us as to how that came about? Why was that a proposal from the local authority that there should be?
Of course, the adjournment was in October, was at the judge's direction to find out more information about the position of the foster carers. The delay then, it was a combination of factors, but it came before the court again in March, at which point the foster carer's position was clear. And the judge asked for an update in relation to the mother, and it was through that the agreed facts were put together. And of course, what is made absolutely clear on behalf of the local authority, because they were agreed facts, they were, the statement says what it is, they were facts about the mother in that intervening period. But within the local authority's final submissions, which were very detailed written submissions, it was made clear that notwithstanding those agreed facts, the local authority's position was unchanged. And the local authority was inviting the judge to assess the risk in the light of the evidence he had heard, the agreed facts, and the history.
Yes.
And all the judge did, we say, is use the agreed facts to say.
Well, I'm curious to know how precisely it came about that we have this document headed Agreed Facts, which sets out, since the hearing in October, the mother has continued to make positive progress as follows. So those are A to L, quite a long list
Yes.
of ways in which the mother's made progress. So was that what was asked? Did the judge ask for that? Or did he ask for a broader document, Agreed Facts? Or how did it come about that we get this summary of agreed facts on one side, as it were, of the case?
It was, and I'm getting a nod from Miss Pollock behind, and indeed Miss Jones, that the judge asked for it and it was drawn up in that way. It was simply so that there would not be, and I will say this and then Miss Pollock will either confirm that this is correct or not, so that it would not need to be the subject of updating evidence. It could be a list of agreed facts, that these facts have been agreed between the local authority and the mother as having taken place in the interim period.
Thank you.
There was not any suggestion by any party that there would need to be any further oral evidence. Each party was content to present their case on the submissions. And as I've indicated, Miss Pollock's submissions were long written submissions that pulled together the oral evidence from October. And perhaps we should turn to those because they are in the supplementary bundle.
A89 in the supplemental bundle, tab 8.
Yes, and they provided the judge with a comprehensive summary of the law that was relevant, of the evidence that he had heard, the written evidence and the oral evidence, and put in place the local authority's position in relation to those changes. And that appears at A100 in paragraph 53. Where it's the reference to those positive steps comes towards the bottom of that paragraph, paragraph 53. Furthermore, whilst the local authority commends the mother for the positive steps she has taken as per the agreed facts document, the court cannot be sure that the mother will not engage with other individuals in the future. And of course, that argument is developed across the document. And likewise, the submissions on behalf of the guardian make the same point, and that's...
You would also rely on what Ms Pollack said at paragraph 60, I think. 60 onwards in her document, wouldn't you?
My lord, yes.
Putting
Because
it all together.
and it's the very fact that there had been similar progress by the mother previously, and that whether it's called mirror concerns, history, repetition, whatever label is put on it, the local authority's case was absolutely clear that the mother had been in that position before. And of course, the judge could have concluded that these changes were significant, but he needed to do that against the history. He needed to consider the evidence of the history, consider the number of times that the mother had undertaken domestic abuse work and demonstrated that she understood the red flags, the warning signs, that she would notify the police and had not done so. And I, of course, will go back to that within the course of my submissions. Stepping back from this point, just to develop the issue of harm and the absence of a proper analysis of all of the evidence, a significant omission by the judge was the absence of almost any proper reference to the harm suffered by the older children. And it is my submission, there is almost no reference to the harm suffered by, and I'll break them into two parts, the three older children and then the fourth child,
Yes.
because they were different.
Different cases.
And taking those points in turn, if we take first the three older children, the only reference to them is in paragraph 7 of the judgment at A104. And the judge records there, it is clear from the documents which have been disclosed that the three elder children had all suffered significant emotional harm arising from the mother's relationships, without any reference to the written material within the judgment, apart from holding it in his head. We do not know quite what the judge is saying, and I would ask you to look at, in the supplementary bundle, A147. And this is part of the Children's Guardian's final analysis for the three older children. And it's dated September of 2015.
Yes. There's probably no need for you to read this out.
No.
You just want to tell me
It's paragraph
what
20.
you'd like us to look at.
Yes, it's paragraph 20.2. And what the Guardian is setting out there is the report of the reporting expert on the three children. And of course, just so that your lordships have the chronology, the children, the care proceedings for the three older children were issued in 2014. They were at that time 4, rising 4, almost 2 and 13 months. So very young children. And this was about a year later.
Yes. Well, shall we just read?
And I'd
do you want
ask you
us to read this?
20.2
to where?
Just 20.2.
Okay. Well, we'll just read that.
Thank you.
Yes. Okay.
Thank you. And the final words of that paragraph refer to their behaviour telling the story
Yes.
of their experiences.
We've read that.
Thank you very much. And of course, the outcome for those for the older 3 children were that they were subject to care and placement orders
Yes.
and separate placement for each of those
Yes.
children. And it is my submission that the line in paragraph 7 from His Honour Judge Wicks of all suffering significant emotional harm cannot be construed as adequate. The harm suffered by the older children is, in my submission, a key feature of the written evidence. It's key to the essential test of the likelihood that the type of harm that may be suffered by the subject child, and it's relevant to the assessment of the likelihood of harm.
So
It's key to the analysis of risk.
can I just ask, were all the 4 children adopted?
Yes.
Or were they placed separately?
Yes. Yes.
And is there any, is the mother having any contact with them? Direct or indirect?
No. My slight hesitation comes from yes, there are no arrangements for contact, but there has been an attempt at there being some contact.
Okay.
But that we would not say that is relevant to the issues within this appeal. But yes,
Anyway, your point is the judge felt...
and of course there's letterbox contact, but
Yes.
in terms of there's no ongoing direct contact or indirect contact, save for the letterbox contact. It's to use open and closed, they are closed adoptions. There is no other reference to the older 3 children at any stage in the analysis of risk, even in passing. And then the second point relates to the harm suffered by the 4th child. Again, the only reference is paragraph 7. And we do have the final sentence of paragraph 7, which, of course, one can imply from that harm, but the judge does not set out the harm suffered by the 4th child. What he does say is there was an initial positive assessment and then a resumption of the relationship, and there was concealment from professionals. And that, of course, is relevant to the assessment of risk. But of course, we say that is not followed through in his assessment of risk and the harm and likelihood of harm for the subject child. He also fails to refer to the transcript that is in the judgment. There is only one transcript within the papers. It's a very short document.
Yes.
And we can see the circumstances in which that judgment was delivered. But Ms. Pollock specifically referred the judge to paragraph, it's at A135. I apologise. The specific referral, if your lordships need it within the written submissions, is at A96 paragraph.
In the
26
supplementary one.
That's the reference within the submissions, and it's in the supplementary bundle at A135. Begins at A135.
Sorry, the judgment is A1.
Yes.
Judge Hughes's judgment is A1.
Yes, that's right.
What do
But
you want us to look at?
yes, and I'd ask you to look at paragraph 3, which is the specific paragraph that Miss Pollock identified as being relevant.
Again, I don't think there's any need for you to read it out. I think we'll read it.
The reference in the submissions, was it page A96?
It was A96
Of
in
the supplemental bundle.
yes, in paragraph 26. And it is, thank you, my lord, because looking at exactly what Miss Pollock wrote and why she was directing His Honour Judge Wicks to that paragraph is she makes the submission that that summary could have been written for this case, underlining the residential assessment and the success in the residential assessment, followed by the resumption of the relationship within the community. And when one looks at His Honour Judge Wicks's judgment and the summary at the end of paragraph 7, he omits the reference to the residential assessment.
In respect to the fourth child.
In respect to the fourth child and the resumption, so the doing well in a controlled community and then immediately resuming a relationship on going into the community with the consequential harm to the fourth child. The fourth child was removed from the care of the mother because of that. And we say that is compounded by his omission at A105 in the background information. Which is at paragraph 11 and 12, where he sets out the sequence of events from the residential to a mother and baby assessment into the community, and the fact that there was an event
yes, December 2023.
In December 2023. What he omits there is the fact that immediately on leaving the mother and baby foster placement, the mother met with the father at a hotel and then subsequently invited him to, it matters not, but the father spent time with the mother at her property, the property that had been secured as a confidential address, at which there was a panic alarm and she notified no one. And,
yes.
And that is omitted by the judge there. And of course it may be said, there is of course reference to that within paragraph 3 of the threshold. And I've already taken your lordships to that, those aspects of concealment, of invitation, resumption, concealment, and then the horrific events after Christmas. But of course the judge does not, in his risk assessment at paragraph 30, refer back to that, nor refer back to that when he sets out the positive progress that the mother had made between October.
In paragraph 34.
Paragraph 34. And there's no link back to that history, to that harm.
And the mother was asked about this when she gave her evidence in Oxford.
Yes.
And cross-examined at some length about it.
She was, and we can, if your lordship would wish to turn to that part of the transcript.
It's in my mind.
Yes, it's A212. Begins at A212. It's the cross-examination by Miss Pollock. And it doesn't need to be read aloud. It follows through over some pages in the usual way, I would say, of the nature of cross-examination, where there was not a clear answer to the questions at different stages that were being presented to Miss Pollock. There was at one stage an assertion that she had contacted the police, which of course was correct in relation to the latest incident, the incident of violence, but not in relation to the contact that she had had with the father.
You're referring to the incident on the 26th of
On the
December?
26th of December, my lord, yes. And of course, within that context, she did use the panic alarm and she did notify the police. But of course, by that time, she had enjoyed many meetings with the father, both at a hotel and in the home.
Yes. I mean, the judge's approach really was that these factors were all had to be considered in the light of the improvements that the mother had made, the progress the mother had made, as set out in the agreed facts. And he didn't carry out, you say, an analysis of whether that was sufficient when analysing the risk.
My lord, yes, and the Miss Pollock's submissions, and they're an exemplary piece of work at the end of a hearing that had taken an unusual course to set out, actually within fewer pages than many advocates would put together at the end of a hearing of that nature, to set out the law in full, to provide a summary of the oral evidence, to highlight parts of the bundle that was over 1,000 pages. And it's not, of course, within an appeal, it's not for this court to say what the answer would have been, but it's the judge's engagement with that and whether or not he accepted those submissions, placed less weight on that as evidence, placed more weight on other evidence. It's just not within this judgment to be able to pull that together.
Where in particular, in Miss Pollock, I hope she doesn't mind dissecting her closing submissions, where in particular do you say she addressed this question, that whether or not the agreed facts were sufficient? Which paragraphs do you say in particular required the judge to consider that?
Well, my lord, I'd say it's throughout, as a generality, but it's the reference to because the real analysis begins after setting out the positions of the parties, begins at A96. And this is summarised. It begins quite properly with the positives about the mother, because there were many positives, and it was not the local authority's case. And the paragraph at 25 makes it absolutely clear what the local authority was asking the judge to do. The word risk is repeated throughout that paragraph. Then in paragraph 26, the question of it being a repetition as it had happened in relation to the older 4 children, that it had gone wrong once she was in the community. And then going through the submissions, particularly paragraph 33, there's the reference to the fact that the home had been made safe. There was a panic alarm. She had a domestic violence worker. And of course, we know, and it's within the chronology in the bundle, that the mother had undertaken the Freedom Programme a number of times in the earlier proceedings as well, and demonstrated a clear ability to understand the risks that arose, that arise in relation to domestic abuse. And there is a reference in the assessment from 2023 at the point that she moved from the residential assessment into the community, and it's in the supplementary bundle at A144.
Just before we get to that point, I mean, staying with Holgate's written submissions, paragraphs 47, 48 and 49, in a sense, cover the concerns of the local authority, but notwithstanding the positive progress that had been made apparently over the period up to March 2025, there were enduring factors which needed to be considered on the other side of the equation.
My lord, yes, and of course we summarise within our skeleton those aspects of the written submissions that were made, and they're set out fully at paragraph 27.
I'm sorry,
It's sorry, A26 in the core bundle, paragraph 27 of our skeleton,
yes.
And we identify there paragraphs 26 to 49, and as your lordship has indicated, 60 and 62, and paragraph 80.
Well, that is it. It's as my lord said, it's the section heading is concerned from paragraph 30 onwards, and then the evaluation at 60.
And your lordships have our points A to N, which pull out from those submissions the points that were made to the judge.
Your case is, as I understand it, that given that very clear and detailed submission, it was incumbent on the judge to address the points made.
Engage with it and address the points made and set out in a reasoned way his conclusions in relation to those. We don't know what those conclusions may have been had we had a reasoned judgment. And I was taking, my lord, and it's point E in our paragraph 27, and I realise that of course all of this is repetition because it's the repetition of what's in the written submissions, but it's point E that the parenting assessment reported that the mother said she would notify the police if the father or any domestically abusive man came into contact with her, and the written information is A144 in the core bundle. The report from the residential placement dated the 8th of October, and it sets out the steps that the mother had taken in securing a property, and records that she is very clear that should she have any concern in relation to a visit from the father or a previous partner or a future partner who was domestically abusive, she would immediately call the police. And of course that was, as my lord has already indicated, the subject of the cross-examination.
Yes.
In October.
Right. Well, I think we have your submissions on that point. Is there anything else you want to add on it?
My lord, no. I was at risk of repetition within the skeleton, and I'm at risk of repetition in these oral submissions.
Well, this is the key. This is the central.
It's the central part, because it is, as I've set out, without that evaluation of the harm and the risk of harm, then the evaluation of the potential placements, it cannot be properly carried out. It's
just so it's absolutely clear to everybody in court, you're not inviting this court to say the judge was obviously wrong and therefore to substitute a care order in this case.
No.
you're saying that because of the deficiencies of the judgment, there should be a rehearing at which there should be, what you said would be a proper evaluation of the advantages and disadvantages, and in particular of the risks.
My lord, yes, and we that is the local authority's position. We cannot say to this court there is only one outcome in this case. It needs to be the subject of a proper judicial evaluation of the evidence.
It does mean it's difficult to see that happening before, say, September, isn't it? These proceedings will then have been going on for over 2 years. The child will have been in her current placement for since then. No.
From January of
January
2024.
2024, that's right. January, of course, after the. That's right, January 24. So over 18 months.
My lord, yes, it's entirely unsatisfactory that such is the result of there not being a properly reasoned.
The evaluation, of course, would then consider the position as it was in, let's say, September, and the mother's position to see if sustained would be arguably stronger than it was before the judge.
My lord, yes, and the local authority understands that. It is not. The local authority doesn't know what the mother's position will be at that point. It would need to be the subject of the evaluation by the local authority and a consideration of their position, and then a judicial determination of whatever application is put before the court by the local authority. We cannot say what the position would be, but the assessment by this judge now in March was, we say, wrong, not properly reasoned, and has to be set aside.
Now I jump ahead, and I don't want anyone to think that obviously we haven't begun to make our mind up. Just so I understand what you're saying here, are you saying there would have to be some further assessment of some sort before a relisted final hearing?
My lord, yes. We know that the foster carers have given notice.
Yes.
And they are
notice under section 44.
Notice under section 44.
Of an intention to apply to adopt.
Yes, and that application, depending on the outcome of this appeal, may be made, and then we've got to look at the landscape at that time in terms of what the competing positions are and the assessments. And of course that is essentially what, of course, the local authority was inviting His Honour Judge Wicks to do, is to make a care order with a plan for adoption and approve the care order, that the application would be made. But of course there would have been an opposition to that.
Yes. Forgive me, I wasn't perhaps clear enough. Are you saying that there would have to be a further assessment of the mother before a final?
Yes, I turned to get confirmation, but I don't see how a local authority, in terms of, because this is all about what is in the best interests of a child, could say at this stage that there should be no further assessment of the mother. It's entirely unsatisfactory, my lord.
Has any...
And it's the nature of that assessment would, of course, need to reflect the assessments that have been undertaken thus far, and it would likely be an addendum assessment building on the assessments that have been undertaken and looking at her position at the point of the assessment. It's not starting from scratch. There's a body of work in terms of assessment.
We may come back to that a bit later. Thank you. Now, where do we go now? You were going to make a further submission. Your third heading was a criticism of the judge's analysis.
Yes, and I've essentially covered that, my lord, because it is, when one looks at the analysis that he did do of the options, and this goes back, we're now back in the judgment in the core bundle. At
It's tab 11, isn't it?
A110,
Yes.
the analysis begins at paragraph 36. And at 36 to 41, we have the judge's analysis and consideration of long-term foster care. And of course, we say that is imbued with his error in relation to the position of the guardian.
And there isn't a welfare analysis going through the factors in the checklist.
No.
Many of which would have been very favourable to the mother.
My lord, yes. And of course, again, he didn't even refer to those analyses within the local authority documents, within the children's guardians document, and the repetition and pulling together of that within Miss Pollock's document, which sets it out in full under both checklists.
Yes. He doesn't deal with the lifelong factors.
Does
in
not deal
section
with
1,
life.
subsection 4 of the adoption checklist.
Yes, and of course,
Which would be factors, if I use that phrase, which would be likely to be in favour of the mother, in some respects at least. So he doesn't address that at all.
No.
So.
And of course makes the further error about the fact that he was working on the basis that there would be no further contact, where first of all, that was not in the care plan. The care plan for adoption included ongoing contact for the mother.
When you say the care plan for adoption,
The care plan that was being presented to the court, as in for the court to approve a care plan for adoption in principle, that what was being proposed is that an adoptive placement would include contact for the child with the mother. And your lordship has already said it, there was no overall comparison of each option against the other, nor any evaluation of the whole against either of the checklists, and in particular the checklist in relation to the Adoption and Children Act. He didn't use Miss Pollock's submissions as an aid memoir or a summary. He could have, one might have expected him to have gone through that, highlighting what he agreed with, what he did not agree with, what was in his head, what he was taking out of his head, to explain why he was reaching the decision that he did. And he simply moved on from paragraph 42 with what we have at paragraph 43, which, and I've set it out fully within the skeleton, he adopts the phrase that nothing else will do, but does not provide analysis about that.
yes.
And my final point is, within the skeleton argument on behalf of the mother, it's asserted that the judge did set out within his judgment the core case of each of the parties, and it's suggested that the local authority's core case can be represented by paragraph 31 of the judgment at A 110. And I say very simply that, of course, was not the local authority's core case. The core case of the local authority was the long history of risk, the significant harm to her 4 older children, her resumption of abusive relationships, her concealment of those relationships, and the repeating patterns of conduct and engagement. That core case does not appear anywhere within the judgment. And my lords have within our skeleton, and it's obviously within the authorities bundle, from paragraph 45 at A33, where I set out Lord Justice Peter Jackson's list about what a good judgment should include.
Thank you.
And I won't repeat what I set out at paragraph 46, unless I can assist further.
Yes, the Lord has a question.
Thank you.
Yeah. You said a moment ago to the court that if the matter does go back, there would be a need for a further assessment of the mother. As at the date of the hearing in March, what was the date of the latest assessment of the mother?
The formal assessment had, of course, been completed within the residential assessment
That back to 2023.
2023, but of course there's the ongoing assessment that appears in the undertaken by the social worker.
There was
the
that as well.
Yes, and so that was within the updating document. So
See, may I just interject? When you say ongoing assessment, do you mean
Well-
the allocated social worker was presenting, as it were, her assessment?
yes, there wasn't a formal assessment by either an independent social worker or a specified agency such as the residential assessment, but the ongoing assessment by the allocated social worker who was engaging with the mother throughout that period.
Yes.
Leading up, there were the updating
Well, in
statements.
case it was any, if I may, just before your second point, in case there any doubt, when I asked you the question, I was asking whether there should be a, as it were, ring-fenced assessment by an ISW or someone like that. Maybe you need to think about that.
Yes, the local authority would need to think about it. It would be a question of a case management decision should the matter be remitted, and the local authority would need to set out its position as to whether there should be a piece of work, as your lordship has indicated. But yes, I would need to take instructions and think about that further.
Another question.
What happened in March 2025, this year, was that the judge was presented with the agreed statement of facts. And on one side of the argument, it was said that this represents a material change of circumstance affecting the way you should approach the history and the oral evidence, including the oral evidence of the mother that you heard in October. And on the other side of the argument, it was being said, no. Was it appropriate to ask the judge to decide between those two competing positions without hearing oral evidence from the mother?
Well, that's the difficulty, and from where I'm
looking back in hindsight.
looking back in
So
hindsight.
what's your position on that?
Yes, looking back in hindsight, I would say that there should have been some oral evidence in relation to that. But of course, the case management decisions at that stage it would be very difficult. But that application was not made, and yes,
Yeah, but it's a matter to be considered by all sides.
absolutely, and that application was not made because, of course, all sides knew what they were, how they were presenting those list of agreed facts, and there was no application by the local authority to
I understand.
challenge that, nor by the mother. But yes,
I've got one other question.
with hindsight, it would have been a good idea.
We know the nature of the incident, the unfortunate incident on Boxing Day 2023, and you told us helpfully that the panic button was pushed on that occasion, and the police were involved. Is there any evidence in previous history to suggest that the mother had experienced previously an incident as serious as that?
There was a violent incident in July of 2023, shortly after the subject child was born.
The punch to the stomach,
Yes.
2 weeks after the
Yes.
caesarean. Yeah, I understand. But we know what we're talking about in December 2023.
Yes.
Yeah.
Yes. But of course, what we have that followed, and of course, this is set out partially within the judgment, but within the documents, that there was not, from the mother's response to the incident in December was not a linear response of, I am now going to take these steps, because of course she didn't support a prosecution initially and then did support a prosecution. And there's also the evidence that was explored in cross-examination about the fact that during the summer of 2024, she was still in contact with the father, because she said it was about the child. And so of course that was explored in cross-examination with her, about her thinking behind continuing any sort of contact. And of course that is reflected in the agreed facts, that there was a change in position. But of course the local authority's position, and it goes back to my Lord's question about agreed facts, but should there have been evidence in relation to them, that there has always been the issue of concealment that the local authority raised, that was front and centre within the history. Thank you.
I just wanted to ask you a question. I'm picking up my Lord Justice Baker's comment about delay in the case, and I will in a moment ask you about the period between October and March. But looking back over the history of the case, the application was brought in July 2023, and although there was judicial continuity at district judge level up to the point at which Judge Wicks assumed responsibility for the case in October, the case did not enjoy, did it, textbook procedural compliance. Indeed, I think I counted 4 occasions on which the issues resolution hearing was listed but then abandoned. So by the time the case came to Judge Wicks in October, everybody, professional parties, the parents and counsel, must have been extremely aware of the very considerable delay already by that stage in the determination of the case. The case was, for reasons which the judge articulated, incapable of complete resolution at that time. One thing that troubled me was reading in paragraph 18 of the judgment that the delay between October and March was attributable to the lack of availability of counsel in that period. Is that right?
I'm being told in part, yes. Yes, and what Ms Pollock is telling me is that had the court given a date, then counsel would have had to attend as a part heard hearing. But what happened was the what happens sometimes and perhaps should not happen is the exchange of available dates. Yes, and Ms Pollock is reminding me that it was listed in January, which council could do, but Miss Geraghty, the Guardian, was not able to attend, and so it was then adjourned to March.
But there was no real reason why the current carers of the child couldn't have, that their situation couldn't have been made known much quicker than January or March 2025. Their situation could have been known very quickly after October.
Yes, and it's set out very opaquely, but because however many times Miss Pollock, and indeed it was one of the questions I asked about why there wasn't the statement that had been directed. And we cannot find the answer in the sense that there's no specific answer. It doesn't appear to be the fault of the foster carers or indeed legal, but somewhere it fell between the arrangements being made for it to be done.
But you wouldn't want to defend the position that this long delay between October and March being attributable to council's availability could be sustained?
No, that's not entirely fair, but because it was the nature of how the dates were being discussed.
It shouldn't ever have been like that, should it?
No, it shouldn't, and that, certainly we don't seek to defend that.
Thank you.
Thank you, Ms Brown. Mr Howe.
My Lords, I will try to weave in some additional submissions to the submissions my Lords have heard from Ms Brown in representing the child taking instructions from the Guardian. We endorse the submissions that the court has heard. Perhaps if I might start with perhaps the central issue is the view taken by the judge that the content of the schedule of agreed facts was demonstrated a change in position that could then be relied upon for the decision made with very little analysis of it. Our instructions are that the schedule of agreed facts arose because a junior counsel who's present today was making submissions on behalf of the mother, suggesting there had been changes, and the judge asked if that could be reduced to writing and preferably agreed. And so that was what occurred. A document was produced that identified changes that had been made. There's no agreement as to the consequences or impact of those changes, just really a list of what the mother had been doing. And in our submission, the document that the court has in the court bundle at page A190 really is just a list without going further to make any comment. There's no agreement in relation to the impact or the consequences of those matters on the evidence that had already been given. The court will have seen the original final evidence of the social worker and the final analysis of the Guardian. Of course, what the judge did have, and we deal with this at paragraph 27 of our skeleton argument at page 53 of the court bundle, is that there was an updating statement from the social worker. And the social worker expressly addresses changes. It's in the supplemental bundle at page A61. This is written evidence before the court, where in the second paragraph on the page on A61, the social worker speaks of in the interim period between part 1 and part 2 of the final hearing, the mother had engaged, and then lists what the social worker records as happening. But at the same time as throughout, particularly that page, we submit recording what was happening on the ground. The social worker then expresses concern about what is still happening. For example, in the middle of the page, social worker says that she remains extremely concerned the mother does not take any responsibility for her decision making, remains adamant all events and the reasons the child is not in her care is due to the actions of others. And as if reading the transcript of the evidence that was given by the mother in October, that was a feature of the cross-examination of the authority, what responsibility was the mother taking. So, in our submission, when looking at the content of A61, which I won't read out in full, we submit that the judge fell into significant error in relying on a list of changes without responding in any way to the evidence before him as to how those changes cannot be seen to be sufficient as demonstrating a sustainable change when looked at the very lengthy backgrounds that Milan and friends already made submissions about. We list some of those matters in our paragraph 28, and onwards. And clearly one of the...
Could I just ask a question, please? When we're looking at that document, could we go back to page A58? I'm just trying to understand what the social worker was basing her assessment on. And she says at the bottom of the page, she lists the assessments and information considered, and that runs down to 2023, goes over the page, it takes us to July 2024. There's a social work chronology, which is on the bottom of page 59, which runs from October 2024 to January 2025. I mean, is it being suggested that this author had any sessions with the mother during the period running up to March?
Not that's recorded in this.
So when we turn to the page that you take us to at page 80, so I beg your pardon, A61, because I mean halfway through that long paragraph it goes back to December 2023. So do we know in reading this whether the preceding information relates back to what was happening at the hearing in October or something which they've gleaned more recently?
Well, on a simple reading of the document, if we look at the second paragraph, where it's recorded in the interim period between part 1 and part 2, mother engaged in domestic abuse programme. In 5 lines down, it says in discussions with the mother, despite referring to the programme work positively and explaining that she feels that she would now make better decisions, I remain concerned. So clearly there is a record there of discussion between the social worker and...
In fact, the new information is not the passage you referred to, which is the second half of that paragraph, but the first half.
Yeah.
Isn't it? Down to
yes, I see.
the first half. I need to recite it all there. That's the new information. Is this statement referred to at all in the judgment?
No.
He doesn't. No.
There's the updated care plan, which is documented as follows at A78. It is referred to, but this evidence is not in our reading of the judgment. Is it's swept up within the catch-all the judge gives as not referring to the not summarising the evidence, as he says in paragraph 27. And of course, the points that were made by the social worker in his statement were addressed in the detailed written submissions made by the local authority, particularly. And the judge has not analysed this evidence, and we say that is really a central flaw in his process.
We may have covered this already, I'm not entirely clear. What discussions were there at the hearing on the 6th of March about whether or not there should be evidence at the hearing, given that 5 months had elapsed since October, and it was said there had been a material change of circumstances?
We're instructed, obviously by Mr. Whittle, who was present, that when there was the adjournment, the judge required the witnesses to attend in case further evidence was required. The further written evidence that was provided was the statement of the social worker that we've just referred to. But then there was an indication from the mother's team that there was no questions to be put on the basis of that statement, and therefore the hearing proceeded by way of submission. I'm turning around to check I've got that correct, and I'm receiving nods. Whether that was the right way forward it is another matter. And as we set out in our documents, that at page paragraph 33 on A54, there was a clear dispute as to the adequacy of the changes made by the mother in the intervening period, and the judge in our submission, again looking back in hindsight, would have been assisted by hearing evidence from the social worker as to why, and that's what he was saying, this wasn't a change that was could be relied upon.
Well, the mother said she didn't want to cross-examine the social worker. Did anybody say we want the mother to come and give more evidence and cross-examine?
My understanding is not. No. So the judge proceeded on the submissions that he had.
And the agreed facts.
And the schedule of agreed facts such as they are. Well, I do say they take, they do require some consideration.
Okay.
Because there are matters contained in here. For example, that says D, and I'm looking at A190 in the core bundle. So, for example, at D, the mother continues to have contact with a centre for victims of domestic abuse. It doesn't say what progress, if any, is being made and the views of those working with the mother. Again, at F, the mother self-referred for further support, but that hadn't yet completed. The mother had put in a housing application. Again, no outcome provided. The mother was on a waiting list for therapy. So these were lists of, this includes work that was relied on by the judge as being supportive of change, when in fact the work hadn't taken place at all, and it was self-referrals to that could achieve change, but there's no evidence that that change had been yet achieved. So when relying on those matters with the strength that the judge did, without analysing the views of the guardian and the social worker as to why, given the background, that they weren't sufficient, this list gained weight that was taken in the round. We say hardly strong and
well, it's quite a comprehensive list, Mr. Howell, of improvements.
Yeah, it's certainly a comprehensive list of steps taken by the mother that might be seen as some evidence of change and evidence of seeking to achieve further change. It's not, in our submission, evidence of the changes that both the social worker and the guardian had said in their documents would be required. So when turning to the issue of risk assessment, which of course was again a central feature, and we deal with this at paragraph 30, page 55 of the court. The judge identifies at paragraph 44 of the judgment when he says the mother has continued to develop the necessary resilience and insights, and this will enable her to protect both herself and the child from the risks both the father and from other individuals who she might become involved with. But then he goes on in the same paragraph saying that this will enable the mother to protect, but in the context of there being intensive support from the local authority. When undertaking the risk assessment, we endorse all that's been said about that. Of course, one important plank of risk assessment is the support that an individual requires if they don't have the resources themselves to manage the risks that arise from the history. And what the judge has not done here, he's identified that there needs to be support for these risks to be managed. He's identified that support, the support required to be intensive, but then doesn't identify at all what he says that should be. There's no direction for a document from the local authority about the supports it might provide under a supervision support plan. There's no opportunity given to the parties as to what they say about those supports the judge then identifies. It's another aspect, we say, of the risk assessment that is erroneous.
Well, he deals with support at paragraph 35, saying given the level of risk posed by the father, the mother will inevitably require professional help or know how to get such help, whether from the police or other agencies. Paragraph 44, he says, the mother will need continued support from the local authority, probably at an intensive level when the father is released. But she's engaged with appropriate support services. She's developing her knowledge, insight, and she now has family around her to support her and help her in times of needs. None of these factors are present at the outset of the proceedings.
How that is going to manage the risk with the history of concealment and dishonesty, it is not a matter that in our submission the judge has addressed that he needed to address, because the monitoring is a clear issue in this type of case, and particularly given the cross-examination that took place of the mother in October, which was about honesty. What did you know? What did you tell him? What did you not tell him? How did he find out where you are? There was a lot of questioning about those issues, which weren't touched on at all by the judge, as to how the mother might be relied upon or not be relied upon to be trustworthy when reporting contact with abusive individuals. Because she said in her transcript, she didn't report because she knew the consequences for local authority action. So we say that when undertaking a risk assessment, the judge needed to identify what the risks are, and if those risks can be managed, identify how those risks can be managed, in our submission, he didn't do that. He just simply flagged up intensive support without saying what it was and how it would manage these risks in this context. So in addition to the submissions made on behalf of the local authority to the judge's approach to risk, we say that is an additional matter that is problematic and undermines his decision. It's not clear to us, jumping onto a different issue, my lords, how it came to be that the judge misunderstood the case being put by the Guardian's recommendation. We deal with this in our preliminary paragraphs in our document. If the written submissions filed
Yes.
on behalf of the Guardian say,
Should we look at those? Can we just turn those up? They're at tab 11 in the supplemental bundle.
yes,
A122. Yes. Where does Guardian solicitor say what it is the Guardian is seeking?
it's A123, my lord. I want to 3 paragraphs up from the bottom, where the child solicitor says the children's guardian endorses this position of the local authority. So a very straightforward statement that the guardian is supporting the local authority plan that the court makes a care order and then the assessment of the foster carers who had by this time produced both emails saying they intended to apply to adopt and then a position statement saying they intended to apply to adopt. That was before the court. And of course, the Guardian had the care plan, the amended care plan that my lords have in the supplemental bundle at page A78. And that care plan provides for, if we look at A80, the completion of the appropriate adoption assessment in 4 to 6 months. And indeed, we're looking at the proposals for contact.
What's the date of this plan, please?
The date of this plan
5th
is
of
the
March.
5th of March,
Yes.
2025. So this was a care plan put together by the local authority once the position of the foster carers had been made clear. And the as we can see from it on page, forgive me, my lord, on page A86, the care plan records the Guardian sharing at the hearing on the same date that she did not support the making of a placement order pending the assessment of the current foster carers. And it says that because the Guardian supports this could be under the legal auspices of adoption. So it's in our submission, a clear position put forward by the solicitor for the child, very briefly, that we accept, but in the written submissions, that the Guardian supporting the local authority.
Is the care plan for the child should be adopted, and we're going to assess Mr. and Mrs. M to see if they are suitable adopters, or is it a care plan that the child should stay with Mr. and Mrs. M, if possible under an adoption, if not under something else such as a special guardianship?
The way that the case was put in the closing submissions of the local authority was that this is a care plan for an assessment for adoption, hence the requirement as set out by Junior Council Local Authority for the welfare checklist under the 2002 Act to be considered. But in those submissions, what is said very clearly give me a moment, what will I just find?
Are we looking at the local authorities closing
I'm
submission?
looking at local authorities closing submissions, my lord, yes.
Yep. Tab 8.
Where, yes, it's paragraph 67, A105. Where the local authority submitted at this hearing, local authority seeks final care order issued before the court is permanency for the child. There is no private adoption application before the court. Adoption, therefore, is not a realistic option today. The local authority has not issued its placement order application at this hearing. The placement order, therefore, is not a realistic option today. Therefore, there is no special guardianship assessment or special guardianship support plan for the court. The special guardianship to the way it was put recently by the children's solicitor, because the children's solicitor was relying very much, and this is at A124, where it's submitted at the very bottom of that page, submitted on behalf of the children's guardian. The correct approach can be found in a RER, where it's proposed the appropriate course of action, and then paragraph 66 is quoted, and then the children's solicitor says the court concluded that a care order application should proceed to a final hearing in which the judge would have to determine the local authority care plan, and if that was so, it was anticipated that final care would be made. The application for placement order adjourned to be determined in parallel with any application to adopt, by which time it would have been validly made. So that was a way forward that was being advocated on behalf of the guardian, that the court should, in principle, decide the issue of adoption, which it seemed the court understood, because Judge Wicks refers to that.
Well, when I asked you what the guardian's position was, your initial response was to refer us to the sentence at 123. The guardian endorses the position of the local authority.
Yes, so
Forgive me, but you've now told us, I think, that the guardian solicitor didn't take the same position in closing submissions from the local
the position of the local authority in the care plan was to make the final care order, and then assessments for adoption to take place in the 4 to 6 month timescale, and then if there's then the court can have before it the private adoption application of the foster carers, or a placement application if that's restored by the local authority. So in looking at the local authority's closing submissions, the reason for submission now is that they seem to depart from what was being advocated in RER by taking adoption out of the off the table for the judge to consider in that paragraph that we've looked at A105. That doesn't, in our submission, detract from the failure by the judge to complete a full analysis of the evidence. What it does do in our submission is perhaps lead to the confusion the judge fell into when the judge characterised the guardian as supporting long-term foster care, when in our submission that was never the guardian's position, and all that changed was the guardian was supporting adoption by unknown carers to an assessment and supporting adoption by known carers.
When the judge says at paragraph 37, having quoted Mrs. Justice Porphyry in the previous paragraph, he says that the guardian's position was long-term foster. Well, that is nonetheless the guardian's position.
Well, we say, my lord, that's wrong. That wasn't the guardian's position. It's not set out in that way in the closing submissions made by written submission by the children's solicitors.
Were there oral submissions supplementing the written submissions? Yes.
I'm told not.
I think I'm on my feet, my lord. The phrase I used within our skeleton was there were exchanges that could not be characterised as formal submissions. There were certainly exchanges in court, but there were not a formality of each party's position being dealt with by way of submissions.
When the judge, forgive me, thank you, Miss Brown, Mr. Howe, when the judge says later on in paragraph 37, she, the guardian, envisages that under a carer there will be a further assessment of the mother, what's that based on?
Well, again, it's not in the document. The children's solicitor's submissions talk about further assessments.
Any additional assessments can be made outside of these proceedings, he says.
And the care plan, the amended, updated care plan specifically refers to further assessment of the mother, because that is dealt with on page A80, paragraph 1.6. Says the local authority will continue to assess whether rehabilitation to her mother's care is in her best interest for the duration of the care order.
Is that what was that included in Mr. Waldhall's observation that any additional assessments could be made outside the proceedings?
I think the reality is the assessment that was primarily being addressed was the adoption assessment of the foster carers, but recognising if there's going to be a period of 4 to 6 months under a care order while that assessment takes place, throughout that period, the local authority remains under duty to consider the position of the mother. And so the local authority would have to be considering whether under the care order a sufficient change had been made by the mother for that to be considered before formulating its view about whether to support, for example, a private adoption application. So we accept that the written submissions provided on behalf of the guardian are perhaps too general in relation to the assessments, where it says that A125, any assessments required if the submission could be undertaken outside proceedings. But it was only those two sets of assessments that were before the judge for consideration. The assessment of the foster carers as adopters, and then the ongoing assessments of the mother. So as we set out in our submissions, it's baffling as to why the judge characterised the guardian's position as supporting long-term foster care, when in fact that wasn't the case, and there isn't a document that says that was the case.
And I suppose 37 needs to be read with 46 in the judgment. Facts simply don't warrant adoption, something which the guardian now tacitly accepts.
Yes, not said. Absolutely.
Well, that's why he says tacitly. ironically.
The guardian withdrew her support, the court to consider making a placement order because the foster carers had served notice of intention to apply for an adoption order, and the guardian wished to see that assessment take place. But that's not the same as withdrawing support.
Well, in considering this submission, these submissions, it seems to me at least we'll have to bear in mind that both the local authority and the guardian's position seems to have shifted. This is not a criticism, it's an observation. Shifted over the period leading up to the hearing in March in ways which it's not immediately easy to discern.
Yes, both the local authority and the guardian in October had filed final evidence supporting a care plan for adoption for the reasons given and making a replacement order for adoption by unknown carers. It was the judge's, I'm told, investigation of whether the special guardianship might be a position with the foster carers that led to the inquiries being made. We accept that in many cases those inquiries might have been made earlier and be before the court.
Was it really the guardian's position by March that the child should stay with Mr. and Mrs. M under one or other legal regime?
We've taken instructions about that. The answer is no. The answer is the recommendation for the child was adoption. There was an opportunity for that to be investigated with the current carers. And then if that assessment came back either negative or the current carers didn't wish to pursue adoption, which was very clearly their position in their position statement, instructed with counsel before the court on the 6th of March. If that then wasn't to be a realistic option for the court to consider, then the guardian instructs us that she would have then reviewed her position at that stage. And then the decision would have had to have been made, given there being a further period of delay, would it be right for the child to stay with the current carers under some lesser order, or then moved to unknown carers, but with the security of adoption? The guardian's view, this was a purposeful delay to investigate these carers. And in our submission, when looking at my lord's judgment in, just give me to find the reference, in page 56 of the authorities bundle, in re are. Paragraph 70. Very bottom of the page, court evaluating the local authority plan in order to decide what order to make the conclusion of care proceedings must have regard, amongst other things, the likely effect on a child of any change in circumstances. Where a child now, in that case, aged 15 months, been placed with foster carers since he was 3 days old, any change of circumstances will inevitably be very significant. Furthermore, when his carers are offering to look after him permanently, have given notice and intention to apply for an adoption order, it's incumbent on the court deciding what order to make at the conclusion of care proceedings to consider how capable the carers are of meeting the child's needs. And then it goes on in ReRPI said the court's statutory obligations when considering an application for a placement order to identify any relevant relationship, consider the likelihood of that relationship continuing, the value to the child of its doing so, may extend to a relationship between a child and foster carers who have put themselves forward as prospective adopters. So the court has to do that, as does the guardian in making recommendations to the court, which is why in our submission, this guardian, it was correct in saying, well, let's have this assessment undertaken, and then if the assessment is not positive, then the guardian has to consider these very matters that the judge didn't consider in his judgment in any way, to make a recommendation for the court as to whether it's best for the child to remain with the current carers under a lesser order, or to be removed. And of course, these are realistic placement options that are being assessed along and being compared with the risks and benefits of being placed with the mother. A side-by-side evaluation that we don't see in any way in this judgment under appeal. The court, this court might be concerned as to why Judge Wicks's misunderstanding of the guardian's position was able to endure. Our instructions are that this judgment was given extemporary. The judge outlined his understanding of the guardian's position in that extemporary judgment. And within 5 or 10 minutes, an application for permission to appeal was made identifying the judge's error in those submissions made on behalf of the local authority that didn't need to be repeated by the guardian. But there was no revisiting by the judge of the contents of the judgment, or revisiting any of his analysis as a result of the misunderstanding being corrected. Unless I can assist for the matters additional to the local authority submission.
Thank you very much, Mr. Howe. Yes, Miss Macklin.
Yes.
Can I just deal with one point that was mentioned a little earlier, which was in relation to the fact that there was no further oral evidence in March. Ms Jones, who sits behind me, was counsel for the mother on that occasion. She tells me that there was no discussion about whether there should be cross-examination of the social worker. She wanted to present further information from the mother, further evidence from the mother, because of what was said to be significant changes in the mother's position. There were then discussions about how that might take place, bearing in mind the limited time that the matter had been listed for. There hadn't been a plan for further oral evidence, as I understand it. And it was as a result of discussions that the agreed written facts document arose.
Yes.
So it's right to say that there was no application to cross-examine the social worker, but I think where I would differ is that there was even any discussion about that. There was no suggestion that there should be updating evidence from the social worker or the guardian.
Well, there's this updating report, isn't there, which Mr. Howe has drawn our attention to, and at the top half of that page, which he took us to,
Yes.
there is updating evidence from the social worker
Yes.
on a limited level,
Yes.
which could be read as undermining the strength of the points made in the agreed facts document.
Yeah. Of course, the agreed facts come after that, my lord.
Well, that is sorry. Thank you for answering that point, which was floating around in my mind too. Was that what was the agreed document? I wondered if that had come after the submissions. It came very late, didn't it?
It was before
Before submissions,
it was
but after
before
the
submissions.
Okay.
But it was obviously after the statement, which was dated February, and very importantly, that statement from February doesn't deal with a number of important aspects of the agreement.
Of the agreed facts, no.
Because I would say, on behalf of the mother, that the most important parts of the agreed facts weren't that this mother was continuing to engage with support agencies, that is important, obviously, or indeed that she had the support of her family, although I say that is important. What's absolutely vitally important is that the mother had continued to remain separate from the father and hadn't had any contact with him, number one. And number two, that she had finally stood up in court, given evidence against him in a criminal trial, and secured his conviction. And those two facts are absent from that social work statement in February, and they are matters which the judge attached great significance to.
Yes.
So I'll come back to that, if I may. But really, this appeal, although it's said by the local authority, is summarised as an appeal because of no adequate analysis or a flawed welfare decision, is in reality, we say, an appeal because of lack of reasons given by the judge. And that really underlines all of the submissions that you've heard on behalf of the local authority and the Guardian, both in writing and today. And of course, one of the points that we make about that is that there was no request for an expansion or further reasons from the judge. And
well, that means, doesn't it, we have to deal with the judgment as we have it.
It does, but there is.
So it's a ground on which you can oppose an appeal.
Well, I simply make it clear that this court has said, and we deal with it at paragraph 35 of our skeleton, in the case of Rianne, or Justice Wall, I wish to make it as clear as possible that after a judge has given judgment, counsel have a positive duty to raise with the judge not just any alleged deficiency in the judge's reasoning process, but any genuine query or ambiguity. And it's said on behalf of the local authority, well, if the local authority had raised that at the time that it sought permission to appeal, it would have effectively been re-arguing its case. Well, we don't accept that. The judge could simply have been asked to give more reasons in respect of his analysis of risk and to set out the evidence that he had considered, that he said that he wasn't going to set out in his judgment.
I think Miss Brown's real point is that on her case, the judgment is incapable of being saved by seeking clarifications. She says that, quoting what's said in subsequent cases, including YM, that it's a case where the deficiencies are such that it's can't be saved by the clarifications process.
Yes, well, of course, we don't agree with that, my lord. We say that, as I have to acknowledge, the judgment is short. I think I used the word brief in our skeleton, and I concede that. But we say the key question that this court has to ask itself is, does the judgment demonstrate that the essential issues raised by the parties have been addressed by the court? And say how those issues have been resolved, and we say that it does. And I acknowledge that Lord Justice Peter Jackson set out in Re B a number of things that he says a good judgment should contain. And this court may find that this isn't a good judgment, but of course that doesn't necessarily mean that the appeal should be allowed. It has to look at the issues in the case and whether the judge has actually addressed the issues and given his reasoning such that this court can understand it. He correctly identified the legal principles which had to be applied. There's no issue taken by any of the parties in relation to that. He sets out the succinct analysis of the law at paragraph 24. And while dealing with that, over the page at A108 of the transcript of the judgment, which is electronic 110, he refers to the extended welfare checklist within his authority. So he clearly had that in mind, and as I'll come to in due course, we say that although he didn't specify every single factor in the extended welfare checklist in his judgment, actually, when one doesn't exercise, one can see that he in fact has addressed all of the matters in that in any event. So we say that he identified the correct legal principles and that he applied them. Part of the reason that the judgment was short may have been, we suggest, that fundamentally this was a finely balanced case in relation to a narrow issue. There was a lot of very positive evidence about this mother's parenting. The local authorities very fairly, in its closing submissions before the judge, described glowing reports in respect of the mother's parenting. Her day-to-day care of the child, her relationship with the child, all of that was good. Factually, there wasn't a great deal in issue. In fact, the judge wasn't invited to make any factual findings by any party at the conclusion of the final hearing. Threshold was agreed, certainly on behalf of the mother. I don't know that it's fair to say that the father agreed it, but he didn't engage, he wasn't there, so there wasn't any substantial factual dispute about threshold. But whenever the judge says that the risk of harm to the child was obvious, and you've heard a number of criticisms of that, he sets out very clearly what the risks were at the beginning of the case in that threshold document. And it may be helpful to look at that within the judgment at paragraph 7. He clearly identifies that the mother's 3 older children had suffered, not simply were at risk of suffering, but had suffered significant emotional harm. And as far as the threshold factors are concerned, the judge sets those out at paragraph 25, where he says in terms that there's a finding at the beginning of the proceedings that the child had suffered and was likely to suffer significant harm. Emotional harm, physical harm as a result of the father having physically abused the mother, including while the child was in the home.
Sorry, where are you now reading from?
Sorry, this is paragraph 25.
Oh yes, in the threshold document. Thank you, sorry.
Where he recites the threshold document.
Yes.
And then emotional harm and at risk of emotional and physical harm because of the parents' inability to remain apart from each other, suffering significant emotional harm or physical harm as a result of the mother not taking protective action to prevent the child from being exposed to abusive ex-partners. Over the page, the child is likely to suffer significant emotional harm and or physical harm as a result of the mother's continuing to come into contact herself and cause the child to come into contact with the father.
These were the risks as at July 2023.
They were, but the judge had all of those risks in mind. So when he's criticised for saying that the risks in relation to harm at the time as of the final hearing are obvious, they're exactly the same as those risks that are set up in the threshold document in my submission. He doesn't need to spell them all out again. He knows what they are. And he clearly knows that the mother's children, the older children, have suffered significant emotional harm because of exposure to domestic abuse. He could have spelled that out, but in my submission it's not necessary because he's clearly aware of that issue. The judge didn't in fact hear a great deal of oral evidence. He heard from the social worker, the mother and the guardian, and I just wanted to pick up one brief point in relation to the criticism of the judge for not referring to the evidence from the mother's independent domestic violence advocate, the IDVA, because that's a point relied on by the local authority. And we say in our skeleton that perhaps unfair to criticise the judge in relation to that. He didn't have a statement from the IDVA, Miss Tiller, that he didn't hear oral evidence from her. In fact, the only reference to evidence from her is in the updating social work statement. In one sentence, this is in the supplementary bundle, page 63.
I'm sorry, I missed that number.
Supplementary bundle 63, which, forgive me, it's A63. Sorry, forgive me, it's A61. It's PDF 63. And it's the very last sentence of the penultimate paragraph. Miss Tiller, Miss Sharp's, the mother's IDVA, has shared that the mother has engaged well with the programme of work and feels as if she's made some progress, but isn't able to say confidently that she feels that the mother would be able to maintain these changes. So it's not fair, we say, for this court to criticise the judge for not referring to that evidence or placing significant weight on it. He clearly made his own evaluation in relation to whether the mother would be able to sustain long-term changes.
On what basis?
Well, he made that evaluation on the basis of the evidence that he heard and the agreed facts. And he placed significant weight on the fact that the mother had managed to maintain a separation from the father for a very significant period of time, and that she had given evidence against him within the criminal proceedings. And that's relevant because, as the judge himself identified, that was a feature of significant concern to the local authority. Up until the point of the final hearing commencing in October, the mother hadn't been willing to take that step, that she had now done it, not simply giving evidence against him and securing the conviction, but also cooperating with the police in relation to finding the father. But also that period of time that it was agreed that she had maintained a separation from the father was relevant. The local authority had suggested that the mother needed to demonstrate that she had been separated from the father 6 months after his release from custody. Of course, we know that he was sentenced to a term of imprisonment in February of this year, but there had been a 4-month period in the community where there hadn't been any contact between them, and that was accepted by everybody. The local authority didn't invite the court to make any additional factual findings at the final hearing. And we say that really the crux of the issue at this appeal is that the judge preferred his analysis in relation to the improvements that had been made by the mother, both as set out in her evidence, but particularly between October and March this year, to that of the guardian, to that of the local authority. And I've already touched on the fact that the local authority didn't mention the giving evidence in the criminal proceedings or the lack of contact between the mother and the father in that statement. And Lord, if I can just go to the written submissions of the local authority, which the court has looked at already, they don't really address either of those matters there either. I think the court was already looking at paragraph 43. Yes. It addresses in one sentence that whilst the mother has supported the prosecution of the father, she failed to follow through previously. The judge referred to that in his judgment, that she hadn't done that previously. So he had clearly taken that into account. And there isn't really any mention of the fact that there had been that very substantial period of time, 5 months, although, as I said, I accept that one of those months was when the father was in custody, where there hadn't been any contact between the mother and the father. So that's where the local authority addresses it in very short order. The Guardian's submissions also address it, but again, in very brief terms. The Guardian's submissions are in the supplementary bundle, starting at A122. Okay. And it's difficult to find where the Guardian, in fact, addresses the progress that the mother has made in that document. Yes, it's in a penultimate paragraph in A123. Whilst the mother should be commended for the work that she's been completed to date, neither of the parents are able to provide consistent and safe care for the child. So there really isn't any substantial analysis in relation to the change of position in my submission in the Guardian's closing submissions. It's clearly a matter that the judge in his judgment felt was significant. He sets out all of the improvements that the mother has made in terms of the agreed facts in detail in the judgment.
Yeah.
He clearly went through those. And that is part of, and a very significant part of the conclusion that he reaches in terms of his assessment of risk.
But putting all these threads together, the case against you is, how can the judge fairly make a decision upon the crucial question of risk without referring to the evidence he has heard about it, and on the basis of agreed facts which are not regarded as being comprehensive, on which he's heard no evidence?
Well, my lord, he didn't hear evidence about the agreed facts, but they do stand as evidence in my submission. I mean, he didn't have written or oral evidence about it because it was agreed. So that is evidence that he was entitled to take into consideration.
Yes, but the local authority case was that wasn't sufficient.
The local authority says that there wasn't enough analysis in relation to that. But the local authority didn't provide that analysis. We've looked at the statement. They didn't address it properly. The Guardian
You mean
didn't.
the analysis of the new material?
Yes.
Yes.
It's not dealt with in that statement in February.
Well, I think we established the statement predates the agreed facts.
Yes, although of course by that stage the mother had given evidence and the father had been convicted, and in fact he was sentenced in February. I don't know the exact date of the sentencing, but certainly the conviction had already taken place at that point. And as of February, there had been no contact between the mother and the father for 4 months at that stage. And it's not referred to, as I've just identified, in any detail in the closing submissions of the local authority and the Guardian. But it was evidence before the court, and the judge completed his analysis in relation to that. So he starts to deal with that at paragraph 33 of the judgment, which is at page A110 of the core bundle. Where he says that the following factors, none of which were present even 6 months ago, all indicate, to my mind, a developing resilience and insight. The local authority says that's not enough because we rely on what's happened in the past. The Guardian seems to take a similar position, but the judge disagrees.
Does he actually deal with the mirror point and the evidence about the past?
Well, my lord, he doesn't. I accept he doesn't specify that, but he does say at the beginning when he's dealing with the history, at paragraph 7, that there's an extensive history of the mother entering into abusive relationships, and an initial. This is page A104. Initial positive assessment, but then subsequently removed after the mother had resumed a relationship with the former partner, and the mother attempts to conceal that from professionals. And he doesn't say in terms that is a mirror of the current situation, but it obviously is. And I would suggest that he clearly had that in mind.
No, he might have had it in mind, but did he do anything with it?
Well, in my submission, it's clear that he was considering that point. But whenever he doesn't specifically refer to it, except at paragraph 32 onwards, later in the judgment. But what he says is that what the mother needs to do is develop resilience and insight to ensure that she remains independent from the father, so that she's able to protect herself and the child from him and anyone else. And then he goes on to deal with all of the significant improvements, as he finds them to be, which addresses that issue. And at paragraph 38, at A111, he says in terms that he doesn't consider that the Guardian has grappled with the key issue, which is the management of the risks that he's identified above. He refers to her original report and oral evidence in October. I accept that he doesn't set it out exactly in terms. But he goes on to say that there have been further positive changes since then, as evidenced by the agreed facts, which of course were also agreed by the Guardian, which the Guardian hasn't fully considered. But he does consider them. Which is why at paragraph 43, he arrives at the conclusion that the mother has continued to make changes and continue to develop the necessary resilience and insight to enable her to protect both herself and the child from the risks from the father and any other risky individual. That's the core issue. In what in my submission was ultimately a finely balanced case, because this is a case where, forgive me for repeating it, but the local authority accept the very significant amount of positive evidence in relation to this mother. This is a case where the mother was successfully caring for this child for months, where the local authority's plan for a significant period had been to place this child at home under a supervision order, which, I would just interject at that point, is what the judge ultimately ordered. He was suggesting there should be a supervision order to tie in that monitoring by agencies that the court has mentioned previously. But ultimately, it was really a matter of a judgment. Had the mother developed that insight, was she able to protect the child? He said he knows what the issues were. He sets out the background. I say in sufficient detail. He says the agreed facts demonstrate that she's shifted, she's moved on. I have to concede that it was a procedurally unusual final hearing. There were changing positions of the local authority and the Guardian. I don't make any particular criticism of that, but of course that always adds difficulty. They were possibly caused by the development of the foster carer's position. And again, I want to make it absolutely clear on behalf of the mother that there's no criticism at all of the foster carer when she says that. Nonetheless, that seems to have caused difficulty and was part of the reason for delay. And for a number of reasons, as the court has already explored, there was a very significant gap of 5 months between the starting of the final hearing and the judge hearing closing submissions. And in my submission, it's rather unfair for it to be said now on behalf of the Guardian, as they do in their skeleton argument, that the judge ought to have heard evidence from the parties. There ought to have been more written or oral evidence before the court, because they had an opportunity to invite the court to do that, but didn't. There were oral submissions made on the 19th of March. I know the local authority is critical of exactly what was said on that occasion. We don't have a transcript, but I think it's agreed that there was an opportunity to address the court orally on the 19th of March before he delivered his judgment. And nobody seems to have been saying at that stage that there needed to be a pause, that further evidence needed to be gathered. There is significant criticism of the judge for misunderstanding the Guardian's position. And we say actually that that's not fair. It may be that he characterised the Guardian's position in a different way than she did herself. But fundamentally, we say he was right to recognise that there was a difference between the position being put forward by the Guardian and that being put forward by the local authority.
Well, actually, the Guardian's position is set out in the judgment. What the judge summarises his understanding at paragraph 5.
Yes. Well,
which Mr. Howe says, he didn't say it in terms, because I didn't remind him of paragraph 5, but what he says is that's wrong in at least 2 respects. She didn't ask, she wasn't supporting long-term foster care. It wasn't right that she wasn't supporting a plan for adoption.
well, she certainly wasn't supporting a plan for adoption at the final hearing. And it is right, I say, that she was effectively supporting a plan for long-term foster care, because that's what happens when the court makes a final care order. I mean, we may be getting into semantic arguments in relation to these issues, but that is the reality. If a final care order had been made, this child is in foster care.
That isn't what the care plan was saying, and the care plan which we were taking to earlier did refer to the Guardian's position as one, I think, as I recall, where it was indicated that she thought that the placement could, I think the word was could, not should, be secured by way of adoption. So adoption was plainly in the Guardian's mind, wasn't it?
Well, perhaps if one looks at the written submissions of the Guardian, which are at A122 of the supplemental bundle.
Yes. I was just looking at 3.5 of the care plan, A86.
Yes.
It's in the child's best interest. Remember, it supports that this could be under the legal auspice of adoption.
Yes, that was certainly the local authority's position.
No, this is a reference to the Guardian.
The care plan quotes the Guardian's position.
Yes. The Guardian believes that it is in the child's best interest and supports that this could be, not should be, I accept that, under the legal auspices of adoption. So
Yeah.
she was plainly contemplating that.
Yeah, she was. I accept that. But the effect of making a final care order left open the possibility of foster care, special guardianship.
Well,
adoption.
I think you have to look at paragraph 5 altogether. At the moment, for my part, it doesn't seem to me that it was right for the judge to say that, on the basis of what we've been told, that the guardian was supporting a long-term plan for long-term foster care and no longer supported the plan for adoption. She was supporting a plan for a care order while further assessments were made, which, I'm paraphrasing now, she hoped would lead or could lead to adoption. So to say that she was no longer supporting a plan for adoption is not accurate, seems to me.
Possibly. She certainly wasn't supporting it at that time. In my submission, it could be read in slightly different ways. He knew that the guardian wanted this child to remain in a placement with the foster carers.
But can I ask a simple question? What the judge does in his judgment, in a sense, is to drive a wedge between the position of the guardian and the local authority. Whereas if you go to the guardian's final submissions, page 1A123 of the bundle, it says unequivocally the guardian endorses the position of the local authority. So whatever their position was, it wasn't something different from the local authority.
Well, it does, but my lord, if one goes over to the next page at A124 in the third paragraph down, it says, it is submitted on behalf of the children's guardian that the current carers are the best option for achieving permanence for the child in her minority. And then it goes on to say in the next paragraph, guardian can't countenance any further delay and invites the court to make a final care order. Now, the local authority's position is slightly different to that in my submission, because in their written submissions at A90, paragraph 8, the local authority say the following issues fall to be considered: whether a final care order should be made with a view subject to assessment to the child remaining in the care of her foster carers in the long term pursuant to adoption, either with a placement order or a private adoption.
Well, if you just go back to A124, which you took us to a moment ago, the following sentence in that same paragraph says any assessments required will be undertaken outside the proceedings.
Yes.
And what sort of assessments would they be?
Yes. Well,
what sort of assessments would they be?
Well, I accept that they are assessments in relation to adoption, as well as assessment of the mother, but they may also be special guardianship assessment. It's hard to tell from the judgment whether the judge is saying that the guardian doesn't support adoption at all, or whether actually what he's saying is, as of today, where we stand, the guardian. But in any event, forgive me, I think it's time.
Yes. Well, I think we'll rise now and resume at 2 o'clock.
Yes.
Thank you very much.
All right, people.
Is the live stream still on?
Yeah, it's still running.
To be the safest, do not swear.
But I just didn't want to trip anyone up by trailing a cable, so if we can charge it for the hour. No, not the call.